Hi guys, it's Kathy. I hope you're doing well. Yeah, I just changed my entire live stream two seconds ago. It's fine, it's fine. Listen, you're gonna like this better. You're gonna say, well, that one was better. Because you're gonna see both clips. I just found one within the last couple minutes that I think we're gonna need a lot of rum for. Man. Why do people go pro se? Okay, he's going to try to explain it in the middle of this spaghetti case that he's throwing around. And it's all tangled, and the dates and the zip codes and everything are just wrong. And the prosecutor's angry. The judge, cool, calm, and collected the entire time. Respectful to this guy. This guy's respectful to the judge until he starts, well, anyway. The prosecutor, anger issues. He needs to take his own anger classes, I think. But that's wrong. That's wrong. That's not the right clip, guys. There we go.
All right, this is State versus Carlise Young. 2507 F322. Mr. Young.
Look how big this is. He is. Because you're gonna need that information later. He's very tall. He's very big.
As a self-represented litigant, state appears by DPA Lake. All right, in this case,
or is
Mr. Young.
He looked tall when he was closer to the camera. Hi, Kelly Love. How you feeling?
Is serving a sentence through the IDOC from Fulton County. Did notify the court of where he was at, wanting to initiate the proceedings. So the court ordered a transportation order to get Mr. Young back. The court did calculate based on the date of filing 70 days pursuant to Criminal Rule 4B, and set a trial date for April 27th. Filed a motion to correct error, stating that the date the court should have used was pursuant to the mailbox rule was a January 5th. Filed a motion to release on recognizance in this case. So, Mr. Young, if I calculate 70 days from January, that puts me to, I think, next week, Mr. Young. First of all, do you agree with that calculation?
Yes, I do.
All right. And do you agree that the 70 days, if I use the date of filing, that the April 27th date falls within that 70-day frame? Correct. All right.
It's not enough, Bobby.
Acknowledging that's where I should start, but you at least acknowledge
Marty's here.
The 70-day window, right?
Saying before I respond.
I understand. All right, so Mr. Lake, you filed a motion to release him on recognizance in this case. Of course, he would not be released from custody because he is being held in the DOC pursuant to a Fulton County case, right?
Correct.
All right, and I assume you're asking that to continue the trial date, or?
It looks like my live is frozen on YouTube's end. Is it spinning? Has my live just stopped? Okay. I think... Yeah, Bobby, I'll switch teams. I'm a really good man. You're enough and everybody loves you. Alright, I think we're good now.
Parameters. I want to make sure.
I'm just saying, so I don't know where if we have a set.
Right now we do. I did set it because
okay.
The first time I got Mr. Young in front of me was Tuesday.
Correct.
Yeah.
Sir.
So.
Oh, it is set for April 27th.
Mr. Young was brought back, was arraigned either last week or this week. Was it Monday, sir, or was it Friday?
Friday, sir.
All right. So he was arraigned brought in front of me on Tuesday the 17th, and I did set it for April 27th.
Okay, I missed that. I was just looking at earlier.
Sure.
So first of all, the case law is that basically the court and the deadlines speak through the CCS entries. And so when he filed this motion, it was filed with the court on February 24th. So that's when you calculate the date from. The mailbox rule would not apply in this case from the prisoner mailbox rule, because that's for filing for appeals and those type of things where it's a date of filing. How can the court set a trial date when we don't receive it? It's basically you get it. And so therefore the state would have lost 30 days of not being able to set a trial. So
Can I?
Hold on, I'm going to give you a chance. Mr.
Okay,
Young.
I would like to
So
respond.
therefore the prison mailbox rule doesn't apply. If it did, it would be next week and we'd move to continue the trial. Based on the calculation though, the state is still moving to release some OR and moving to continue that trial just because we're trying to get in touch with the victim, and there's going to be.
And that is a bunch of bull. With the state, he's incarcerated for something else somewhere else. The state is releasing him on his own recognizance on this case. That means that speedy trial is blown out of the water, and it removes a lot of his rights. It means as long as he's incarcerated, he is not accruing any time for this case either. But that's not important to him right now because he thinks he's innocent. But what it means is trial dates and everything like that are, if you are incarcerated, you get the trials first in the docket, in the calendar, court calendar. If you are not incarcerated, then you don't. Now he is incarcerated, but not on this case, so it doesn't count. He's OR'd on this case. He's released on this case.
This is why Julia's here, is that there's a lot of evidence that in this case, body cams, those type of things that have to be provided to Mr. Young. And it's going to be, we have to do that on a laptop computer to allow him to view it. And I don't know how that's going to be done. That's kind of what the issue is, that I'm not sure that he'll be fully prepared for trial by April 27th. I think I will, but I would rather continue it so that we can make sure that he gets everything and that we're all on the same page.
Okay. All right, Mr. Young, I said you would have a chance to speak, so now is your chance, sir. Go ahead.
However, the prison mailbox rule does apply because the state had adequate amount of time to answer because it reached, I sent the certified mail. So what they did was basically just looked at it and probably ignored it, not purposely, but, ignored it and didn't respond to it. So actually it gives them an adequate amount of time to be able to file. They're supposed to file from the time they received it. So I'm also stating that I'm objecting to any continuance or far as OR, because at the same time I wouldn't be able to be the 70-day rule is so I wouldn't be maliciously detained. But however, since I'm under Department of Corrections authority at this point, I'm still incarcerated, I still wouldn't be able to receive any relief by them ORing me. And I'm also objecting to the habitual offender that they sent in, because you have to have I have to have a notice.
I promise he is trying to say habitual. Habitual. He keeps saying it incorrectly. Oh, Louis.
Within the 10-day mark, they have to give me some type of notice or some type of written for me to be able to argue this within 10 days, according to.
You got that. You may not have, because
I've got it. And then they gave me 2 felonies that are, the habitual statute states that it has to be unrelated. Both of the felonies are related. So the habitual isn't substantial in the first place.
filed at least 30 days prior to the trial date. I note your objection. Infirmities with what they're alleging, Mr. Young, that's a defense.
Okay,
But in terms of them filing it,
okay, that's fine. That's
your,
fine.
your objection is noted for the record, but under 353415, it was timely filed. So I'm going to deny it on that basis. But to be clear, Mr. Young, if you believe that the offenses that are alleged are either do not comply with the statute or
It doesn't.
are not good, that still remains an area for you to object.
Okay, that's
All
fine.
right. Now, Mr. Young, I've already cautioned you on the perils of self-representation. You're adamant you want to represent yourself, and I've made it pretty clear I'm willing to give you an attorney. And I think that would be a good idea because you told me that there may be a witness out there that can say you were somewhere else. That's an alibi, which you have to file, Mr. Young.
Correct, but for the record, you stated that if you did grant me the mailbox rule, you were going to grant them.
Court acted as soon as it could when it was aware of when you had let the court know where you were. I would not have been able to predict back on January 15. Now you're saying the state, you had filed letters to the state. I don't have those.
Okay, but
Hold on.
mail runs, it said they received it January 15th. That's not when I sent it out. I have the certified receipt that states that I sent it out on the 12th. They said it received on the 15th.
Well, I'm just looking at the envelope that was, when you filed your motion,
They said it
the speedy
received on
trial.
the 15th.
Hold on, you and I cannot talk over
Okay.
each other. I'm gonna let you talk,
All right,
but we have to make sure that because we're recording this.
okay.
The envelope you filed a couple of these, so let me see. The first one that I have, Mr. Young, was shown, it's file marked February 24. The envelope that's included is stamped January 15. Okay.
So what I'm saying is what happened to the other 45 days?
What other 45 days, sir?
Okay, so how the mail works.
Mhm.
If I send a letter out and it's certified and I pay for it, which I have the receipt, all right, and it receipts, okay, say on the 12th, let's hypothetically say this. Hypothetically say that it went out on the 15th and they didn't receive it until the 18th. Where's the 45 days? So they don't have to respond when they receive it? They can just leave it there?
Well, if you send something to the state directly, the court is not aware of that. Okay, you sent a copy to them. I don't know when they received it.
I'm saying when the county clerk received it, it would have been, say hypothetically, on the 18th, correct?
No, what I'm telling you is,
So they trying to say they didn't receive it. I sent it on January the 15th. They didn't receive it to the 24th of February?
I'll give you a copy of the file stamped
I
thing
understand
that I have.
that.
It says February 24th of 2024.
I understand that. I have the same copy, sir, of the
Right.
file stamp. I'm asking the courts today, sir, and I'm not trying to be because no.
Do not ask the court. I'm sure that's a felony. And I think it might be a pretty bad one. I think.
way and question your authority.
No.
What I'm asking you is simply, if that is the case, it went through the mail, they received it. The clerk did. They just filed it on the 24th. They didn't receive it on the 24th. They filed it on the 24th. So what I'm asking is, where's the other 45 days? So they can just respond whenever they want to? They can just file it whenever they want to?
One way I'm getting confused is because when you use they,
What I mean is the state can, it would be the court because they would have to file it. So the court can actually file it when they want to?
Well, the clerk is a different office than the courts.
Okay, so the clerk can file it when she says.
Generally speaking, Mr. Young, they file it when they receive it. I don't know. I can't explain to you I mean, you sent it certified mail, but that doesn't mean it gets sent right away. I mean,
But
they
if the
filed it
post
when they got it.
If the post message, if the postal is January the 15th, that means they received it in the next one.
Well, here's what I'm getting at, Mr. Young. Look,
I'm saying that's why, what I'm trying to get at is that's why that's why the rule was in set. So it would protect that's why the rule was in set. That's why it's not obsolete in this term. In this particular setting. That's why I'm saying, that's why I made the motion to correct error. This is why the rule is for. So we don't have these type of debates, because that's what it protects me in a situation to where they can't just the clerk can't just receive the mail and just say, okay, well, we'll get to it later. They have to respond to it. They have to file it as soon as they get it.
and they did that here. That's their general practice, Mr. Young. Here's what I'm going to tell you. Look, the mailbox rule is designed so that, yeah, you don't forfeit maybe an appeal or something along those lines because you mailed it from the jail at or near the deadline and the Court of Appeals didn't get it till afterwards. But here's the deal. The problem is you want me to say the clock started January 15. I didn't get your filing until February 24. Now, if that were the case, if I use January 15, Mr. Young, that means that your trial has to be set by next Thursday. And there's no way that's going to happen. The court can't accommodate that, and the state certainly can't get its subpoenas out. So it's going to be kind of moot because, Mr. Young, I am going to grant the state's motion to OR you in this case because you can't have your cake and eat it too.
You're a jerk. You're a jerk. How dare you give him an OR when he can't go anywhere? He's still incarcerated. He doesn't say this much. I don't know if he says it at all, actually, but that means he doesn't get credit for any time that he's serving right now on this case. That sucks.
You can't tell me that, hey, I needed to use January 15 and therefore you need to have your trial by next Thursday. I can't accommodate that, Mr.
Okay, can I ask you a question?
Sure. I don't know if I can answer it, but
okay.
Go ahead.
Is my motion being granted for the mailbox rule?
Well,
Okay, so then,
I'm releasing you on recognizance in this case.
but what I'm saying is that the state would have had adequate, if that's the case, if it's being removed, 60 days is adequate amount of time. They've had a year to have my case prepared. So why would they need to OR me? What I'm saying is almost a year. This is March. It's 9 months old. What I'm saying is that, so why would they receive the benefit? If I'm not getting received the benefit of my mailbox, you deem it, incompetent. I understand that. Well, why would they be able to receive the benefit of ORing me and having extra time to prepare? Well, because what that does is stop my fast and speedy because they've OR'd me.
Exactly. Because I cannot accommodate your demand to have a trial by next Thursday.
But what I'm saying is that if you didn't grant my motion.
It's both, Tona. Here's what happened. And they're going to explain it more, don't worry. But he sent a certified letter on January 15th. The court did not file that letter until February 24th. There's a reason why. I'm not gonna spoil it, but that's what the problem is right now. He sent this certified letter and paid for it. So actually, in his possession, he has a receipt and the letter and everything that he's gonna present to the judge that says that he sent it on January 15th. That pisses off the state, the prosecutor, and then he's gonna explain why they didn't file it until February 24th.
I deemed it moot, meaning it's no longer relevant.
What I'm saying, so if it's no longer relevant, then why we couldn't stick to the same day of April the 24th, I believe.
Well, right now, Mr. Lake is moving to continue that trial. Are you moving to continue or not?
Yes, Your Honor.
And you're objecting to that?
Yes, I'm objected to it. Yes, I am.
Well, here's the problem, Mr. Young. You're representing yourself. Here's
Correct.
Here's how this is going to play out. Because you're no longer in custody on this case, you're going to be sent back to Putnamville. So how are you going to review the discovery if you're in Putnamville?
Well, at this time, that's what they can send it to me. And then
Well,
my
they can't-
counselor, they can mail it to me. They can mail it to me. They can send it to me. They can mail it to me. And I can review it with my case manager, my legal liaison. That's my legal right. I can review it there. And even if they OR me, I'm still not receiving any relief. See, it's a lot of things that I tried to get to the law library here. I went there. They had nothing in there. They had nothing. So what I'm saying, the thing that I wouldn't be able to
I
file.
bet you there's a pro se guide for dummies in there. And those books on things for dummies are not all that bad. Just saying. Some of them have good information in there to start a new journey.
Build a adequate defense here anyway. When I get there, I can file affidavits for my subpoenas. I can do a lot of different things. I can do more research. Here, I'm idle. I don't have. It's almost like you're telling me, I'm coming. Now I'm just using this hypothetically in the lamest terms. It's almost like you're telling me I'm 6'7", I'm fresh off the street, having exercise, and telling me to go guard Shaquille O'Neal, who's been seasoned and exercised and has all the right equipment to train.
So we saw how big he was when he was walking in, remember? I said, look, because you're going to need this information later. I think he'd be okay guarding Shaq, right?
That's not going to be a good matchup. They're gonna smoke me because I don't have I don't have the material.
First off, Shaq smokes everybody. You're not alone. Second off, you're pro se. They were always going to smoke you. Always. There's nothing you can do to change that. Nothing.
Tools to be able to defend myself properly. But there, I have a state-of-the-art law library that I can attack and I can research cases and I can file motions. I don't have that here.
Well, I'm giving you that because I'm sending you back to Putnamville.
But I'm ejecting. Still, I want it on file that I ejected to the OR. I want that on the record.
It is. Everything that you're saying.
And then I'm fine with whatever you do from here. Thank you.
Well, hold on. Now, we've already established, Mr. Young, that when you mail something from Putnamville on January 15, we're not getting it right away.
I want to start a petition to change the name of something, since library is very difficult for inmates to say. But the Spanish language has a perfectly lovely word for library. Biblioteca. I want to start a petition to change library to biblioteca in the English language. I need people to sign it, please.
I'm saying that I send a certified mail. Listen what I'm telling you. Okay, let me show you this. It says received on March the 14th. March the 3rd.
All right. Well,
So they received it.
I need to see what you're looking at.
Okay.
So can you hand that to Miss Maupin so I can see what you're looking at?
Okay, see what I'm telling you. Let me show you. You filed it on January 14th. You filed it, sent it to me, mailed it out to me on the 24th.
I haven't mailed you anything.
No, I'm saying the clerk did or whoever
Okay.
did mailed out the mail from me filing on the 24th.
Are you wanting me to look at whatever?
Yeah, yes, I would.
All
I'd
right,
like
Ms.
him so I
Maupin.
can explain it because he's probably not understanding. I'm talking too fast. Can you please take that to the judge so he can understand what I'm stating? Thank you.
Whatever it is. All right. So, Mr. handed me a photocopy of an envelope
With
from
a
the
postal
clerk
date.
with a received of March 3rd of 2026.
Correct.
What was in this?
It was the file date. It was received on the 3rd of March.
I know, but what was in the envelope?
The filing date of granted of my I'm trying to find that now. Granted of my here it is right here. I was granted of you guys filed it and received it and filed it. So I received it actually less than 7 days.
Hand that to.
Can you see that?
Maupin.
Less than 7 days after you guys mailed it to me.
All right. So what happened was you mailed this to the clerk
On the January 15th.
I gotcha. And then you received your file stamped copy in this envelope, and it's marked received March 3rd, 2026 at Putnamville, correct?
Correct. So what I'm stating is, well, let me break this, make it more clearly. Let me slow down because I got a lot of thoughts in my head.
Sure.
All right, what I'm stating is basically, you guys received it hypothetically whenever they filed, they received it. I'm saying they received it on the 18th of January. They, denied filing it or whatever, or however, probably a lot of paperwork. They filed it on the 24th of February. And then they sent me a copy that day stating that they filed it, or say they sent it on the 26th. I received it less than 7 days later.
I'm going to show these to Mr. Lake, okay?
So what I'm stating,
He doesn't need to see him.
so what I'm stating is that the mail there's no problem getting mail. That's not the problem here. The problem I was stating is that they received it.
If I told you that the per se gentleman was the actual problem of the mail not getting there, would you believe me? Would you, since he just showed receipts that he sent it certified? Would you believe me that he might be the whole problem?
They just didn't act on it.
Your Honor, may I be heard when he's done?
Of course.
But that's what
I want to let Mr. Young finish what he's telling me.
But what I'm stating is that they received it, they just never responded to it. And then, however, and this is another reason.
Josh, you're more of a hammer guy than an axe.
No, I'm cutting you off I want to be clear, because when you say they.
I'm saying the clerks received it.
Okay.
Or and maybe they had to converse with the prosecution, but they never responded to it until the 24th. They received it in January, sometime in January, and never responded to it. Because you can't tell me that the mail system that they sent it's postal marked it, and I got it because I certified mail, I paid for it, and I have the receipt. You can't tell me that they give me my copy, and that this is what that would have been. I could have sued the postal office. This is a
skin color.
This has been a fraudulent document. This is why you pay for certified mail. I paid for it to be certified, which I have the receipt, and they received it in between from January. Say the postal date says January the 15th, as I'm correct, $1.63.
I gotta interject because that's not true, Your Honor. He put the wrong zip code on his original mailing. That's the reason for the delay. If you look at the original mailing, he has 46628. 01 is written over it in a marker. So that never got delivered to the St. Joseph Clerk's office until February 24th. That's the date that it was received.
Okay.
And so therefore, the fault is on him. He put the wrong zip code on the original mailing. The delay is his. He may have mailed it on January 15th, but it didn't get here.
No,
because he put the wrong zip code on.
No.
Well, can I also interject to what he just stated? Okay, this is not like this is one thing for sure that the mail, even if hypothetically, let's say I put the wrong address on it. I still put St. Joseph County Clerk's office. They know where the mail people here have been living here all their life. They know where St. Joseph County Clerk office. That's why they corrected it.
Let me correct you, sir. That's not how a mailroom works. See, you have all these different pieces of information on an envelope for a reason. The first thing they do is look at the zip code, and then they sort mail for that zip code, and then it goes to that zip code. And then when that zip code gets the mail, then they look at the address. Oh, wait, that's not in this zip code. Put it aside. We have to figure out what the zip code is. And then eventually somebody figures out what that zip code is. Then it goes back into the zip code piles, and then it gets mailed out to them. And then they look at the address. Nobody looks at the address first and then says, oh, he messed up. Nope. Your letter got sent all over the place and had a whole bunch of people looking at it.
For me, they know where that's at. So it wouldn't have been that much of a delay. They know where that's at. The delay was that the prosecution refused to acknowledge it. And then this is what I said. I didn't want to release all my information that I didn't study, but now I got to start. Now I got to go ahead and give you enlighten some things.
No. Don't you try to enlighten people, you are already in a hole. You just messed everything up. Brent, I go to the post office at minimum 3 times a week to mail things. Not for me personally. I pick my daughter up from work. She works for a roofing company. Whenever you do anything on a roof, you have to get a permit. Permit offices do not accept any kind of online or electronic. You have to fill out these. You have to go online and get the form, print it off on a piece of paper, fill it out in triplicate, make copies, 3 copies, 6 copies, whatever. They all want something different, and then physically mail that to the government offices. That's the way the government offices work. It's all right. Now this guy's gonna enlighten us. So should we like meditate before enlightenment or something? I feel like it's a big deal. If I'm gonna get enlightened, I wanna celebrate it in some way. Now just get enlightened. Here we go.
All right. Hypothetically, say the filing date is the 24th. The prosecution under Brown versus State, the prosecution is given 10 days to respond to the defendant's request for a fast and speedy trial. If the prosecution fails to serve a warrant before the speedy trial is requested, the prosecution is a direct violation of a Fifth Amendment due process. So they forfeit their chance to even postpone, continue, or to even inject recondits. They lost that. They lost their right when they didn't respond to my.
Oh, that felt good. Are you guys enlightened? I am enlightened. They lost it. They just lost it. That's the word.
Fast and speedy. That's a direct violation of my Fifth Amendment right, due process. Now, I didn't even want to disclose all the things that I've researched, but I'm not going to no longer.
It's not trial by surprise, Mr. Young. So if you have arguments you want to make, and
but what I'm saying,
everything is on the record.
That is on the record. That's on the record.
TJ, keep it PG.
If they forfeited it, now they can look at that. They can look it up. They forfeited because they had 10 days to respond. They forfeit all their rights.
Well, here's the situation, Mr. Young. Okay, first of all, whether or not the thing was filed on January 15 or February 24 is moot. Because in any respect, as we sit here right now, we're still in the 70 days. I've granted their motion for OR. We're no longer there. But you have made your record, and these issues remain available on appeal if that is necessary.
If that is necessary. Okay.
Because obviously if you're acquitted, this is all moot.
Right. I understand that.
Now, the only reason I brought up the delay in the mail is this, Mr. Young, because you're representing yourself. Right. You're saying you want to file all these things. You may want to subpoena witnesses.
I'll have the right address this time.
Hold on. You'll at least acknowledge, Mr. Young, that there is some delay in getting this stuff.
I'm going to send it certified mail.
Whether it's 5 days, whether it's 45 days.
I still want to be listen, right now, listen, they don't have public defenders like you anymore. I watched you. I tried to hire you. I don't know if you remember years ago.
That's so cool. I watched you. I tried to hire you years ago. He liked this person when he liked this judge when he was a public defender. I thought that was really cool. Bren, maybe it'll help keep my bumper on. maybe that's all I need to stop my bumper from falling off. Thank you.
I watched you. They don't have public defenders like you anymore, sir. And I ain't trying to disrespect the judicial system. Right now, they would only be a puppet for the prosecution. I would be facing 2 prosecutioners. He would think I'd be a know-it-all, so everything I would ask him to do.
They are not. They are hard-working attorneys. They just are.
He wouldn't be able to do it because he's not getting paid, listen, this is a profession. I totally understand.
No, he wouldn't be able to do it because it's not the correct thing to do in your case. He's going to do what he thinks is the correct thing to do, not what you want him to do.
And that, sir. So all the research I've done would be in vain. I'd rather take my chances, and I don't think they have a very good case. when I introduced all this other things.
Mr.
Because
Young, I'm not trying to take away your right to represent yourself.
Okay.
All I'm telling you is this. Right now, with the April 27th trial date, if you wanted the court to subpoena witnesses, it's going to be too late because you're going to be sent down to Putnamville. I don't know when that's going to happen. By the time you get your research done, you're going to ask me to send a subpoena. We may very well be inside of like 7 days of trial. So,
What he just said right there stressed me out right away. I'm stressed out for this guy now. I feel so bad for him. I'm stressed out for him. And they never resolve what he just said. They never resolve it. So we're just going to bed stressed out tonight. There's nothing I can do about it.
you haven't even reviewed the discovery, have you?
no, I haven't. I don't think they only have a bunch of police statements. They don't have anything, sir. Because I know listen, when they came and seen me when I was incarcerated, see, they probably he's a prosecution out, and I respect this guy. I don't know him, but I respect Mr. Lake. He has 10,000 cases. He don't review mine. He don't know really actually what's in there until it's the last second till he has to. He has 10,000 other cases to worry about.
He just
It's more
knows.
relevant or more prevalent at that time. So he doesn't know what he has and what he doesn't have. He doesn't have anything but a bunch of police statements. When they came and viewed me when I was incarcerated, because they knew I was incarcerated, they came and viewed me while I was there, the detective. And my wife at that time presented him with
I think he meant interview. Because they don't just come and view you when you're in prison. I think he meant when they came and interviewed me. But I could be wrong.
a legal document, an affidavit stating that I was at work with several witnesses. So I couldn't have been there at that time. He said that he had a liking that they said. So what this is really about is not about me being there. It's about, I didn't tell who was there.
Well, to be clear, Mr. Young, I don't know what any of the evidence is.
Okay, but I'm telling you, they don't have any. I know what they have.
Well, here's what I'm going to do, Mr. Young, because right now the state is asked to continue the.
I don't want to continue.
I know you don't, but I am going to continue.
That's why I'm objecting to the continuance. I don't want to continue.
And that is on the record. And the reason
I was wrong. They did rectify it. I missed the whole continuing part. I don't know how. I was scrambling to get this in the last few minutes. So that's good, guys. We can breathe. We can relax. They're going to continue the trial. It will not be April 27th. I do too, Josh. I do. I like this guy. I want the best for him. And he's making all these mistakes.
I'm granting it is because you're representing yourself. You're being sent back to Putnamville, and you don't even have the discovery yet. Now, the state, you're going to have to provide Mr. Young with the discovery in some fashion. You haven't.
I have most of the paper. The rest is digital, body worn surveillance, and call records.
Oh, I cannot wait to see the body worn. Oh, do you think they're going to play it in trial? Because I'm getting the trial. Don't worry, I get everything from this guy. Oh, I can't wait.
Okay.
From a couple of different places. So,
Mr. Young, can you advise me? Are you able to view digital evidence in Putnamville?
Yes, I am. My case manager, my legal liaison, she would let me review
in what
everything.
format? Like a thumb drive?
Yes, I would be able to review a thumb drive or a CD-ROM, any of the two, whichever one's more convenient for them.
All right. So on this date, you're being handed a vast majority of the paper discovery to at least get you started.
Okay.
With the rest of the discovery is going to be sent to Putnamville.
Correct.
Now, you're representing yourself. I need to give you time to look at this, file whatever motion so we can address those. I'm looking at a trial date, Mr. Young, of June 22nd. That's Monday, June 22nd. That's roughly 3 months from now. Does that give you sufficient time
No.
That's more than
to
enough
review
time.
the case,
No, it's not
file
enough.
whatever motions you want filed?
I'm guessing, and I don't know. I don't know. I have no reason to guess this, but I'm guessing it's going to take her 30 days to get a CD-ROM. I know. I'm guessing it's going to take her 30 days to get him discovery. I don't think she's going to. They have it, but he's incarcerated. So how do they get it to him? What Mr. Lay said was, and my religion teacher in ninth grade was Mr. Lay, and he was really cute, which made religion class difficult. Very, very, very difficult. But anyway, now I forget what I was saying because I thought about Mr. Lay. Oh yeah, Mr. Lay said that he was going to load it onto a laptop. So if they do that, it'll be fine. Load it on the laptop, go visit him in jail. He looks at the discovery. He can't have it, but he can look at it, take note, whatever notes he needs to take, and then that's quick and easy. But I don't know how she's going to get him this discovery. It's going to take 30 days. So that leaves 60 days left. Okay? He needs to subpoena his witnesses, if he has any. He's incarcerated. So it'll take him, 2 weeks minimum, if he writes the right zip code on, to get the subpoena request sent to the court, and then the court file them. That leaves 45 days left for them to to find the witnesses and get to the witnesses. I just don't know. I don't know if that's enough time. I feel for this guy. I'm trying to help him in my mind, and he is unhelpable.
To file whatever subpoenas you want filed so that you would be sufficiently prepared for trial on June 22nd.
Yes, that's
Lake, does that work for the state? Because I'm going to tell you this.
Yep.
I'm going to set that date, and this is probably going to be the only case I set that date, because
Yep.
this
That
is
would-
going
that
to be
would-
a date certain.
Yeah, that's what I was going to ask.
What I think, and I don't know, T, but what I think is the body cameras or the dash cams or the cameras at the business or whatever the crime was, I get the feeling that they have a photo, a video of him near the crime. And that's what they got. I don't have the feeling from everything they say in here that they have him dead to rights. I think they have a video of him near the crime. And he's saying that's not enough. That's why he's going to win this case.
This could be a date certain because that's.
So here's where we're at, Mr. Young. Now, what I'd like to do is set up at least another hearing with you to appear from Putnamville.
that'll be fine.
And maybe actually not just one, but maybe a couple hearings.
That'll be fine. I think I sent you a motion for that, if I'm not mistaken.
Well, you did, but the thing is, you sent me the motion after I'd already issued the transportation.
All right, that's fine. I'll
Entry
agree to
was-
that.
It was moot because I am already getting you here.
All right, that'll be fine, sir.
So here's the thing. You get transported back by the sheriff, and I don't know because they don't drive to Putnamville every day. So I don't know.
Brandon, you don't know how much I would love to do that. I would do that in a heartbeat. In a second. I would do that. Except for one thing. We never reach out to these people. Never, ever reach out to these people. We've observed court. We don't interfere. We're like the Talamasca. Oh, is Nan here? Nan! She's not here, is she? It's like the Talamasca. Anybody know? Okay. But we can't reach out to these people in real life. That would be crossing a boundary. That would be cool though. Very cool.
When you're going to be sent back, but I'm going to order that they send you back as soon as possible.
That'll work. I'll talk, the one who usually transports me back, he brought me over here. He'll probably bring me back. He's the one who does the most of the transporting. Me and him, we got a pretty good repertoire. I'll tell him the importance of it because I really.
We got we got a pretty good repertoire. That was mean. I couldn't help it. It hit me. That was rude.
That way I'll
I'm
be able
rude.
to get back and be able to do a little bit more
Now,
research.
Mr. Young, let me ask you this, because I have some individuals who are incarcerated in other penitentiaries who are denied access to the law library absent some sort of specific court order. Do you need that from me? Or
Yes, I would.
have you been given access to the library?
Yeah, but in this case, I ain't gonna lie to you. Putnamville very, very good on giving it to you regularly. But in this case, I need to be there every day. So in that case,
So
I would need a court order.
What does it need? What is the language you need my order to say?
That he would be able to attend the law library whenever he needs to. And that'd probably be every day. So I can view a few other things.
Well, you understand that I could put that in the order. I have somewhat limited control over that because that's between the
they're
warden.
they're really good at honoring judges' orders. Listen, I don't have no argument with Putnamville. They're gonna, and plus me and the law library clerk, me and her she tried to get me to be a clerk there to help guys with their cases.
You're doing a good job here in court. So I just want to make sure that I'm giving you what you need to make sure you're going to be able to prepare for the case.
That'll be fine.
Now, so here's what we're going to do. Over your objection, Mr. Young, I am ordering you released on this case. However, the court does note you are still being held in the Indiana Department of Correction pursuant to your Fulton County commitment. I am also showing over your objection, Mr. Young, that I'm granting the state's motion to continue. And essentially, I'm granting it to allow you an opportunity to review the discovery and get this case prepared for trial. I am setting this case for trial on Monday, June 22nd to commence at 11 a.m.
I've heard of electronic restraining orders, JK. Give him one of those.
Now, let me ask you this, Mr. Young. You have family members out in this community?
Yes, I have only one left, a sister. All the rest of my family lived in
Well, the reason I'm asking is this. So for anyone who represents him or herself, I generally can't have you appearing in front of the jury wearing your prison outfits. So
I'll
you have someone that can bring you clothing that you can wear.
Yes, I will.
All right. Now, I want to right now I'm going to say at least two because there may be more, but we're going to have a couple of telephonic status hearings or maybe by Zoom. And I'm going to set these on Wednesdays because that's the day that Mr. Lake is typically in this court. This is a special exception. He's here on Thursday.
Oh, it's Mr. Lake, not Mr. Lay. I misheard them this whole time.
Here on a Wednesday.
All right.
So, Mr. Young, the first one I'm going to set is going to be Wednesday, April 29 at 9 a.m.
That'll be fine.
The purpose for that is just to see, do you have the discovery? Have you received the digital discovery? Is there any issues opening it? Just so we can check out where things are at. If you have motions that are filed, you can address them on that day. Any other matters we need to take care of?
I think I'm just gonna I'm gonna do it two ways.
I think she is. I think CJ's a Gen Xer.
So you might get a double motion. Let the court reflect that. I'm gonna send an email, e-file, and I'm gonna send it by mail, so it is no misunderstanding on how it gets.
Can you actually e-file from Putnamville?
Yeah, you can e-file it too. So, but I'm gonna send it both ways, so it'll be here. So you will receive one e-file and one.
Why don't you e-file this thing?
Because I wanted to do it manually this time. Because I was reading case law. It's better to do fast and speedies manually because it gives me a little.
We wouldn't have to deal with the mail issue.
Yeah, that would have been true. I should have thought of that too. I didn't, but
you got to make sure that everything
I thought the MA.
You serve the state.
I'll make sure
I can't act on things that you file that aren't served.
I'll make sure they get it too.
Now,
and can I get would their fax number be the same as the courts? Or how?
Can
because
you
the
fax?
e-file. I mean, because the e-file runs off of fax. A court it sends it to the clerk.
Well,
the clerk
there is an email address for e-filing for the prosecutor's office.
I don't have it.
From defense at stjoeprost.
They're not gonna have it there. They only have the clerk's office. So is it possible I can get it in some type of writing so I can?
Well, they're gonna mail you discovery. So why don't you find out what your e-service email address is?
See, See, that's why Gen X is so cool. You can call us whatever you want. You want to call us a boomer? Okay, we don't care. We don't care. Call us whatever word you want to call us. We don't care.
And could they please send it to me?
It's in the public list of when you e-file something, you just search my name.
All right.
I'll just have
Do you
them
know
search.
John Lake?
Yeah, I know
All
Mr.
right.
Lake.
All right.
And then, Your Honor, just,
There is one word I wouldn't want to be called. One word. It starts with an R, but that's the only word.
I would ask the court to issue a discovery order so that Putnamville is aware that we're going to be sending electronic discovery and that he is permitted to have that and that it is to be provided to him without them. I'm very familiar with the DOC.
I know you are.
I dealt with it, and I'm very fearful that they're going to grab that and not give it to him, and we're going to have an issue. So I'm happy we're having this hearing on the 29th to see if there's any issues with the discovery. But
All right.
I want to make sure that he has everything
Okay.
in a proper format. So I think an order from the court directing the superintendent to make sure that Putnamville, that he does have access to that, and whatever, otherwise we might have to, what I've done in other DOC
No.
cases.
I appreciate. All right. So, Mr. Young, this order will at least include many things, but one, that you have access to the law library as you need, and two, that you be allowed access to the digital discovery that is coming from St. Joe County in case Putnamville won't give you that. Now,
Can I also let the record reflect, if I happen to start to have too many problems, then if I come to too many problems, what would be the deadline for me to ask for a public defender to be able to?
there's no deadline for that.
Okay, to be able to referee that.
The only deadline is going
I
to
just
be,
would have to deal with it.
the only deadline is going to
get
be, you can't ask me for a public defender like the day before trial.
Oh, no,
when I
it would
haven't
be
called
way
off the
before
jury.
that. I'll make sure I do research.
Now, here's what you need to understand. If you're asking for a public defender just
No, I'm not asking for it. I'm saying if it's going to be a problem with me receiving things, maybe a legal representation would be more adequate.
but our public defenders are not going to be driving down to Putnam. You have to understand that.
No, I can call him on a phone. Couldn't I call him on phone?
Okay. All right, hold on. The next thing we're going to do is set another status for Wednesday, June 3rd at 9 a.m. All right. So, Mr. Young, first of all, do you acknowledge your trial date has now been set for June 22nd at 11 a.m.?
Yes, sir, I
And
do.
we will issue a transportation order. And I'm not worried about this with you, but I have to tell everybody, you understand that if you refuse to come to court,
Man,
we just,
how am I refusing? I'm in the Department of Court. They not going. They gonna change. You going to
I
court?
know, Mr. Young, I just have to have that on the record.
Yeah.
So you're acknowledging if you did refuse to come to court, well, you wouldn't have an attorney then, because you're your own attorney, right?
Correct, sir.
Now, Mr. Young, we are setting status dates April 29th at 9 a.m. and June 3rd at 9 a.m. And the court will reach out to Putnamville to coordinate those. There is one caveat. Sometimes when we try to do that, Putnamville or the DOC is like, well, we can't do it that day or whatever. Any complication, we're going to reset as close to the dates that I'm setting now, because I want to have these hearings. I'm just letting you know that sometimes when we try to set these up with the DOC, there are issues.
I know.
All right. And I've already said I've granted both their motion to ROR and to continue the trial over your objection. So those matters remain available for appeal if necessary. You are being handed paper discovery today. And then you will be getting the digital discovery and whatever else you need from the prosecutor's office in short order. I'll order that you be transported back to Putnamville. The court will issue a transportation order to bring you back here for your trial. In all likelihood, Mr. Young, that will be just the week before trial. If for whatever reason we need to have a hearing in court, we'll bring you back sooner, okay?
All right, thank you, sir.
Now, anything that you raise in a filing, I would certainly suggest e-filing it so that way it gets to my attention quickly and that way it can be addressed quickly.
I'm definitely gonna e-file it from now on.
But if you also want to supplement that with paper filings, that's not.
I'm gonna do it both ways. I'm gonna pay for it, and you gotta pay for both of them in this Department of Correction. I'm just gonna pay twice.
All right, now let me turn to Mr. Lake. Anything else we need to take care of today on this case, sir?
No, Your Honor.
Now, Mr. Young, anything from you, sir?
No, sir.
All right, very good. You'll be transported back to Putnamville. All
Have a
right,
nice day, Mr. Lake.
You too.
all right, Mr. Young.
All right, you too, Mr. Princess. And man, I don't know how you do it, man. You look younger every time I see you, man. What's going on? What time you do that, man? What's that, man? What kind of?
Well, for the record, Mr. Young, I think you'd hold your own against Shaquille O'Neal, sir.
No, he wouldn't. No, he wouldn't. It's Shaq. No one can hold their own against him. Come on, Judge. I'm sorry, I'm talking. Jeez. All right, now we're going to go to the Judge Fish one that was going to be the first clip of today's live stream, and I put the thumbnail and the title and the description up for this clip, and then right before I started to go live, I've changed my mind. The wind blew. So I cut a bunch of testimony out, all right, because they simply just repeat the same thing the other guys said, and I did not want to listen to it again. I mean, we listened to it enough. I kind of like that guy too. I really do. Okay, JK, you're right. All he did was interrupt the judge. He should have been held in contempt and gotten another year. I forgot to turn the rice on. But now we're going to see Judge.
We've been having some trouble with our live stream, so hopefully it doesn't give us the same fits.
It does. It's going to echo for a tiny, itsy bitsy little bit at the very beginning. And then it'll be fine. Amy, hi! But I already know you guys are going to lose your mind over it. All right? But it only lasts for a minute, guys. Really.
But if it starts echoing throughout the courtroom, then we'll deal with that. State, would you please set a record for Miguel Luna?
Yes, this will be State of Indiana versus Miguel Luna, 64 D01 2404 F5 3369. Defendant appears with counsel, Attorney Cantrell. States represented by Deputy Prosecutor Hammer. We were set today for sentencing.
We might still be live streaming, but I don't know. Yeah. Very strange. State, evidence or argument for sentencing?
Your Honor, evidence would be the previously submitted victim impact that was.
He is delicious, isn't he, Amy? He is so good. I love watching him. I do. Oh, believe it or not, guys, a lot of his dockets are kind of boring. They're just him being a judge. But his personality, when it comes out, is excellent, on point.
I believe
We're gonna listen to some sob stories at the beginning, or maybe not sob stories. We are gonna hear some sob stories. We're gonna hear those, but we're gonna listen to redemption stories, and then we're gonna see how Judge Fish takes that into consideration.
submitted through the probation department. Did Your Honor receive that?
I received a statement today.
Yes.
Is that the one?
Yes.
I received that.
Okay.
I had a
The
chance to review it this
Fish
afternoon.
family.
Okay.
There is no I in the Fish family, Josh. There is no I.
You said you had a chance to?
I did, in fact, have a chance to review that this afternoon.
Okay.
Yes.
Yes, that would be the only evidence State would be submitting at this point, Your Honor.
Okay. So I get the file. We will admit that into evidence, assuming there's no objection.
No known objection to that, Your Honor.
Thank you. Mr. Cantrell, evidence or argument for sentencing, sir?
Yes, Your Honor. I have a couple witnesses, Your Honor, if I may.
Sure.
Okay.
Going to be sworn?
Yes.
Okay. I think you said Tim. Just come around. Yeah. Please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth? Yes. Okay, thank you. You can be seated.
Good afternoon, sir, and thank you for coming. Would you please state and spell your name for us?
Timothy Cagle, Cagle.
And how do you know Miguel Luna, sir?
I've been a volunteer at the Porter County Jail.
Good. He's a volunteer at the jail. So I should definitely not say to you, "Nice darrow, champ."
The God Pod.
Well done.
And he's been a participant.
I know that he's been incarcerated now for about 680 some odd days. Is that correct?
Yes.
And, is that during this period of time, those 680 some days, is that when you got to know him?
Yes.
What have you observed? I know you wanted to speak and come here this afternoon, so thank you for coming first and foremost. But what did you want to say that you've seen and like you've seen changes in Miguel? Would you please tell the court?
Yeah, I've seen tremendous growth and change in him. He's one of the leaders in the pod now, and he's just a pleasure to be around. He's very active and leads other people. He's a great role model for other participants in the program. He's just really positive. I've seen his entire outlook change over the last several months.
When you first got to know him, I think when he first got in there, he was pretty damaged and broken. Would you say that's correct?
Yes, definitely. And I've really seen him just give it all to God. And his positivity it's really it's ruminating throughout the whole program.
Do you think it's genuine, sir?
Yes, 100%. I wouldn't be here if it wasn't.
I understand. Is there anything else that you would like to add or anything else that you would want to say on behalf of Miguel, or you'd want anything else that you think that you would want the judge to know?
Just respectfully ask for leniency, because I think that his change really is genuine. And I think that he could be a very productive member of his community and could do a lot of good. I think that he's a good man.
Do you think he's had some significant impact on other inmates as well?
Oh, 100%. I've seen it.
And you said that he's a leader?
Yeah, he leads. I know he leads some prayer circles in the evening. And I remember you were telling me, he was telling me that just a lot of, he's just a good influence, I would say. Very good influence.
And thank you for coming today. The prosecutor may have some questions for you, sir.
No, I do not.
Okay, thank you. Sir, you can step down. Next witness, sir.
Rick?
I heard Atlantic Star for the first time in 30 years on the radio the other day, and it was magical.
Good afternoon, sir. Could you please state and spell your name for us?
First name is Eric, E-R-I-C, Ison, I-H-S-S-E-N.
Thank you. And
Thank you, Zach. Thank you so much. I appreciate it. I really, really do. Guys, I'm going to see Zach, maybe. I maybe see Zach soon. He's going to come and join me at my job. He's going to watch a show. I'm Zach, I'm very, very excited to meet you. I think it's going to be a great show. Your daughter is going to have a blast. She's going to have such a good time. It's way better than you think it's going to be. It just is.
how do you know Miguel Luna?
How do I know Miguel?
Yes, sir.
Yeah, I'm also one of the God Pod leaders on Wednesday afternoon.
And have you been volunteering in that program the entire time Miguel was locked up?
Yeah, I've been there about 4 years.
So in the just shy of 2 years that you've got to know him, have you noticed a change in him, sir?
Yeah, he's gotten more serious about his walk with the Lord. When I first met him in the group, it was kind of like, don't know if this is going to stick.
Okay.
But you could tell he just got serious about what we were doing, and he wasn't attending just to be attending. You know, he was really getting something out of it and contributing as well, asking a lot of questions, taking it seriously.
And I thank you for coming today, and I know you wanted to come here and speak on his behalf. What did you want the judge to know, and what information can you provide for us to try to help the judge in determining a fair sentence, sir?
Well, I think he's had a real change of heart, a real change of attitude. And I know that, you know, you can fake that.
You can fake good attitude? No, you can't. I think 5. I feel like I'm missing one person and I feel bad, but I don't remember who it is. I think I met 5 vibers in real life. I went to Houston twice to Judge Fleischer's courtroom. I met some each of those trips. And it's the first trip I can't remember if I'm missing one person. And then another person who I also saw in Houston, Donald, came to Lancaster and we went out to dinner. So 5, I remember of 5 vibers I've met in real life.
But after a while, the fruit comes out and you can tell what's really in the heart. And I think what's really in Miguel's heart is a genuine love for the Lord, a genuine desire to change his ways and to walk the right path now and to give it all he's got. Like I said, he's very serious about his walk with the Lord.
Do you think that if the judge saw fit to give him a break or showed him some leniency, that he would squander that, or or do you think that he would take advantage of it, sir?
No. I mean, you can't predict.
Sure.
But given what I know, given what I've seen, and given what I've seen with other people in the past, he's headed on the right path.
Okay.
I would want to add that he made it a real point to get baptized, which is a sign of true conversion, while he was in jail. And he had to go through a rigmarole to get that done. So you tend to think there's something serious going on here.
Now, based on what I was learning, I don't think that is a common occurrence inside the Porter County Jail. Is that correct?
I've only known 1 or 2
And
out of maybe 50.
Okay. So, like, what's different about Miguel than the other people who are going through this process? Or if you could.
Well, kind of like he's serious about it. He's had a genuine heart conversion. So he's a different person, you know, in his heart than the way he came in. Now, that's no guarantee of how his future behavior is.
If I had a nickel for every time I heard, oh, he's changed. Oh, he's a changed man. Oh, I'm changed. I'll never do that again.
Going to be, of course, people make choices.
Sure.
But chances are good that he's going to stick on the right path.
And you've seen those changes over time?
Yeah.
Thank you. Is there anything else that you wanted to add today, sir?
No.
Okay, the prosecutor may have some questions for you. Thank you for coming again.
No.
State.
Okay, so there's 3 more God Pod people, I think. They just say what he just said. So we're just gonna, cut most of it out.
No, Your Honor.
No questions, sir?
No.
Sir, you can step down.
Thank you.
Further evidence, sir?
Yes, Your Honor. We're almost done. Terry?
Okay.
Fish got a haircut.
Please raise your hand and be sworn. You swear, affirm, or upon perjury to tell the whole truth and nothing but the truth.
He probably gets one every couple days, doesn't he?
Good afternoon, sir. Can you state and spell your name for us?
Terry, Terry Makowicz, Machowicz.
Thank you for coming today. How do you know Miguel Luna?
From the God Pod, so I'm one of 9 or more men that go in to teach classes, basically, Bible classes.
Have you gotten to know Miguel Luna?
Very much so.
Please raise your hand and be sworn. You swear, affirm, or upon perjury to tell the whole truth and nothing but the truth.
I do.
Okay, thank you, sir. You can be seated.
Good afternoon, sir, and thank you for coming.
Probably you would, Bren. Here's why. Because that would be the truth. That would be the truth. It's jail.
Would you please state and spell your name?
Jeffrey, Jeffrey, Reeder, Reeder.
And how do you know Miguel Luna, sir?
I'm a facilitator at the God Pod as well.
And what did you want to tell the court on behalf of the growth that you've seen for Mr. Pena?
Raise your hand. You swear affirm under penalty of perjury to tell the whole truth.
That's how much I cared about the growth you've seen.
Good afternoon, sir. Could you state and spell your name for us?
Yeah, my name is Thomas Machesko.
If anybody does want to hear all this witness testimony, let me know. I'll throw it up in members only, or I'll throw it in Patreon. You just let me know.
ThomasMuchesko.
And sir, how do you know Miguel Luna?
I'm like the other gentleman. I'm part of the Biblical Life Principle Program, better known as God Pod.
Thank you.
Your Honor, before that, I just wanted to make clear for the record, I have had a chance to review the pre-sentence investigation and I have no changes, corrections, or modifications to it. I don't know I can't remember if we.
I didn't mention anything about it, no, but I appreciate you bringing it up. Anything from the pre-sentence report for you, sir?
Your Honor, the circumstances attending the commission of a crime, when going through this document with my client on page 2, that's the full paragraph in the middle of the page, and my client doesn't agree with the information contained in there. You just want me to let Your Honor know that for the record.
So this is on the second page, in the middle, the narrative.
Yes.
Okay, and for the record, he just wants me to note he doesn't agree.
Correct.
Okay.
Yeah.
We'll note that for the record, sir. State.
Thank you, Your Honor. Your Honor, just to touch base on that, he says he did all the things that are said in there in the pre-sentencing report under the thing and now is trying to disagree. He's already contradicting himself between the defendant's version on page 11 then if he's now throwing at issue what happened on page 2. Your Honor, what we have here is a manipulator. I think it's pretty clear.
What we have here is what, sir?
A manipulator.
Oh.
Through the submission by the state with the letter, this is somebody that has played the long game, so to speak. He goes for the long part of it, using the kids, forcing somebody to either work, not work, go through that and influence them one way, shape, or form. And even being in the jail did not stop that, where he had picked up 2 invasion of privacies that were issued by, or not invasion of privacies, but in violation of a no contact order issued by this court, as well as the even more egregious invasion of privacy to the point of influencing through the obstruction of justice charge, Your Honor. And I'm not talking to the heart of either of those cases. I'm just saying he willfully violated 3 times at least that we were able to, that we've charged with that. And they got increasingly worse to the point of trying to influence the testimony of somebody else. The lengths and the type of the abuse that was prolonged. This was not just a physical case of abuse, Your Honor. Through the letter from our victim, there was emotional, physical, financial, not letting her have a job, not having a car, putting debt on her. More concerning is that it affected these kids both being under the age of 18, which is an aggravator statutorily, Your Honor. There were 2 kids there, and as said here, it's affected them. It may have taken them a while to come around and realize that, Your Honor, but given this, he's affected their lives permanently. And it sounds like it's still ongoing and may never, in fact, get better. The abuse in this case was bad enough to begin with strangulation. If that wasn't bad enough, you add the aggravating factor of the kids were present. That ups it to a level 6 felony. And then you had it gets worse. She was pregnant with an unborn kid. Regardless of whose kid it was that she was pregnant. Those lethality factors, Your Honor, are extremely concerning given his history. He was trying to control the victim again from the jail, using the kids to guilt her or otherwise push her. What's going on here, Your Honor? And he will do or say whatever it takes to get out of the jail. And that's what we're seeing here, Your Honor. He tries to manipulate one person. It's not successful, so he tries another way. That's what we're seeing here. Concerning when you look at his defendant statement where he says in the PSI, he knew he was pregnant. So it's a regardless of who it was, and still attacked her. This intentional disregard shows extreme anger and lack of control, making him a significant danger to society. Also of concern in looking at his PSI was a case in 45 HO1 0112 CM 891, where it was a domestic battery that he was prior convicted of. Here, more importantly, it is noted that defendant walked out of the court and was found in contempt, Your Honor. Again, another violation of court order. As you look through his PSI, there are multiple times where he's been given probation, given all these other chances, and fails miserably. He's failed to appear at least 5 times through state's review of the PSI. He has this pattern of disregarding judicial orders and thumbing his nose at the court, which he's done in this instance again to the court multiple times. If nothing will keep him from violating a court's order like being in jail, that's of great concern as well, Your Honor. He willfully violated from the jail, the place that you would think would be the best able to control of following court's orders and allowing him to do so. He did not do. He didn't even care that he was on a recorded phone line doing this. It just was something he did. His prior attempts, he's been given prior attempts for rehabilitation, and they've all been proven to be unsuccessful. He's been in programming. He's done this. He's done that. And he tries to fall back on cocaine and drinking to minimize his behavior, which he did again in this case. His behavior dates all the way back to his juvenile history, which is extremely concerning given the types of charges that have been throughout his history, Your Honor. His history through the PSI indicates his willingness to harm others. He mentions he needs to be there for his kids. However, he's not court ordered to support them or otherwise pay for them. And he's been incarcerated again for 2 years so far. They're fine without him, Your Honor. This is an instance of we don't need him out there teaching his kids, his female daughters, it's okay to be beaten, or his male sons to go out there and it's okay to beat women. That is not okay. He's admitted to being gang affiliated. The aggravated battery charge, while being dismissed, was dismissed because there was a lack of witness availability and passage of time, not due to that. And that case is of note because it was against another family member, specifically a son with family members. And that was an extremely egregious battery as well, Your Honor. His significant incarceration in Michigan for dealing shows, again, previous attempts for rehabilitation, which have also failed miserably. As an adult, he has been arrested or charged 26 times, resulting in 4 misdemeanors and 1 felony, not including the case here, 4 of which are a battery-related charge. And again, while I can't ask you to enhance the sentence due to the invasion of privacy or the obstruction being what they are, I can ask you to enhance the circumstances based on the fact that he was willfully violating court orders and thumbing his nose directly at the court in this instance, this court, because of all of that, Your Honor, by what he was doing. And again, this shows that he was violating bond pretrial release and is otherwise not taking this seriously, Your Honor. Again, he is minimizing his behavior and not really taking full responsibility for it. And again, he was offered, without touching about what the facts were, was offered plea agreements prior. So to say now that he wasn't offered any in his defendant's version is short-sighted and misdirected. Given all of the enhancers, again, beyond the force necessary required, the fact that there were minors present, two minors present, and then the effects on these 2 individuals, his danger to the community, and his failure for probation, parole, or otherwise, his additional attempts at rehabilitation, as well as violating the protective order issued and recently violating conditions of probation, parole, community corrections, Your Honor, I believe far outweigh any mitigators that this court could find.
That's his normal face, though. That is his happy face, and his mad face, and his bored face.
Therefore, the state is asking the following in each instance for the strangulation upon a pregnant woman, 6 years, Department of Correction, none suspended. Count 2, the battery with minors present, 2.5 years, none suspended. And count 3, 1 year on the intimidation, none suspended, all to be served consecutively, Your Honor, for a total of 9.5 years, Indiana Department of Correction. And state would also ask that a no contact order be issued as a condition of any sentence that you impose.
So I don't get mad, hardly ever. So as soon as I heard him ask for consecutive, I started looking up. How do you decide whether it's concurrent or consecutive? What does a judge, first off, is there rules they have to follow, or is it all just the judge gets to pick? Okay. Indiana and some of the other states, but we are in Indiana right now, so I specifically looked at Indiana. There are some crimes that you must make consecutive. All right, and he didn't commit any of those crimes, just so you know. One of the biggest factors in consecutive versus consecutive, concurrent versus consecutive, is the number of victims. So if you committed crimes against one person, or like one spree, one thing, that's usually concurrent. If you have like a bunch of different victims and a bunch of different crimes, if you are out doing this to a whole bunch of people, then it's consecutive. But it is up to the judge whether it's consecutive or concurrent. But that's the thing they put the most weight on, is how many people this affected.
Thank you.
Thank you. Was there a no contact order entered as a pre-trial measure? Is that the one you want to be maintained throughout the term of the sentence?
Yes, Your Honor.
Was the victim consulted related to that term?
Yes, Your Honor.
That request, rather?
Yes.
Okay.
Witch hazel. That helps.
Mr. Cantrell?
Your Honor, Mr. Luna is about 10 years younger than me. I know him and his brothers. I got to know him really, really well because my nephew started dating his niece, his brother's daughter. They went to Andrean together. They ended up going to college together. So I had, just family contacts at like graduation parties, birthday parties, and he was doing really well. Miguel was killing life. He had a construction company. He was getting licensed in all the different municipalities in Lake County. He was passing tests. He was really doing well. And then his kid fell off the back of a motorcycle and died in 2023. Miguel Jr., it's referenced on page 12 of the PSI. And he just stopped doing anything. He had a business. He was in the middle of jobs. He just fell off, and really, like he had court proceedings. He started getting sued. I couldn't corral him to even get him into court. I quit representing him because he was so far gone. Like I didn't want to represent somebody and he doesn't have any money to pay me, and I'm showing up there and
He pulled out the kid card. Oof, that's a hard one. That's a hard one. So when I first got married, I had two conditions: no planes, no motorcycles. We were allowed to fly places. We flew places, but he wasn't allowed to get a pilot license or a motorcycle. No, because I didn't want that stress and worry. I didn't. Now I know better. Now I will actively encourage it.
not showing up. I just got sick of it. And, this period of time, I really thought that he's changed. I've seen it, and then I hear what he tells me has been going on in jail. He's going to tell you and go through all the certificates he received. this presentation today, I mean, that's all. It's hard to get people to come in. It's hard to get one person to come in. I think that he's impressed a panel of humans, and it's not manipulation, Your Honor. I think it's genuine change. He needed a timeout. He really did. Honestly, he probably would be dead if he wasn't incarcerated. That's the truth. He messed up. He started using drugs and getting drunk, like wasted every day. And that's the truth. So this sentence, whatever you give him is a timeout that he needed, but I don't think based on the accusations, you know, he did say, like, I was drinking every day, I was using drugs every day, I was having a ton of problems every day. He did say those things, but he didn't, all of those things that Ms. Meyer said happened, all that stuff didn't happen. He's not agreeing to that. He just knows that. And like, I just think that he was up for a few days using drugs and alcohol, and some chaos ensued. They were fighting all the time, but he's a good person. He really is. If his kid didn't die, he would have probably several $1 million a year business and employed 50 people, because that's where he was headed. And it's just tragedy struck, and he can do so much better. He's proven himself to all these gentlemen that are here today. And I know that Mr. Hammer doesn't like him, and he hasn't necessarily shown his best side to the courts here, but he's capable of so much more. It sounds like he's in a great place now, and he's come so far through religion and this time out. Like, if he was related to me, we would have snatched him up and put him in rehab. That's really what he needed. And, you know,
I wonder if his ex and his kid, who got severely beaten by him, I wonder if they're in a good place right now. I wonder if they've come so far. I wonder if they still remember. I wonder if they hear like footsteps and get scared for no reason.
his family tried to do that and couldn't get him to go and stay. So this period of incarceration is something that dried him out, reset him. He's done a ton of work with coping with grief and all the faith-based progress that he's made. I know that a lot of people think people go to jail and find God. This seems genuine. So I'd ask the court to give him a sentence that you think is fair. Probation did, in fact, suggest that he should get 3 years of incarceration and then 2 years probation and then time on the other 2 counts. And all that time should run concurrently. And I think that's a fair recommendation. He still would have to do more time.
Thank you, Monica.
And I think that he maybe still have some more work to do here in the jail. So I would ask the court to consider following probation's recommendation. I think it's fair. Probation went through everything in respect to Mr. Luna and spoke to a lot of people within the jail. And
read that again real slow, Bren. Read that again real slowly and figure out if that sentence makes any sense.
I think this recommendation is based on facts, not just assuming that you know a lot about somebody just because of an incident that happened. Thank you.
Thank you, Counselor. Mr. Luna, this is your chance to say whatever you might like to say before I rule on the case. If you'd like to exercise that right, I would just ask that the microphone be pointed towards him so he can make his allocution.
Yes, Your Honor.
Yes, sir.
I'd like to start off saying I take full responsibility and accountability for the charges of my actions, Your Honor. I'd also like to state a deep apology to Jennifer and to all my kids, to all my loved ones, my brothers, my sisters. I have 10 other children. I know they've struggled these last 2 years that I've...
He has 10 other children. 10 other children. Okay. First he said, I'd like to apologize to my wife, Jen, my brothers, my sisters. Then he said, I have 10 other children. He didn't really talk about a child to begin with, though. So, do you think he has 10 children or 11 children? I don't know. Hi, Brown. I'm guessing he has 10 children.
Been in Porter County Jail.
Kelly, thank you so much. I appreciate it. Thank you.
I was a member of the church for lots of years as a Catholic, St. Stephen's Mariners Church. On September 10th of 2023, I got a phone call that my son had fell off the back of a motorcycle and died. He was 23 years old, about to be 24 at the time. It's my grandbaby behind me that he left behind in his death. And I was shattered as a dad. I was lost. I was broken. And a lot happened in them 6 months where I just lost faith. I was mad at God. I couldn't find answers for the emotions and feelings and thoughts that I was going through. My birthday was March 22nd. On that day, it was a bad birthday. I mean, without my son, without the family gathering, I was going through so much emotions as losing a son, but not only losing a son, I was having to deal with all the emotions of my other children, missing their brother, the younger ones asking when brother was coming back, the older ones just lost without their younger brother. It was hard to find answers. It was hard to tell them that everything was going to be okay as a broken father. On March 29th, I had these charges brought on me. On April 30th, I did surrender. And then on April 30th, I was brought back to Porter County Jail. And I've been there since, Your Honor. The most important thing that I could have found in all the years of going to church, to a Catholic church every Sunday, sometimes Tuesdays, sometimes Fridays. I was doing a lot of things on the side, helping the church. The most important thing did happen in these last year and a half. On March 17th to 25, I was entered into the God Pod, Chaplain Berkey, and I found a relationship with the Lord that was so amazing for me. And I will admit, as counsel said, I'd probably be dead right now if I hadn't came to jail. But with the relationship I've gained with God, I know that He had a purpose. And I'm asking for time served or the rest of this time, Your Honor, with probation so that I have an opportunity to evangelize to others that have lost children and to make a difference in their lives before they make the mistakes that I have made, Lord.
My cat just fell right off the table onto the cord for my camera. She fell off the table because, you know, cats are great.
In this case, Your Honor, I do have 10 other kids, Your Honor, and I care about my kids very much. I gave Jennifer a home. On the 7th day of 2024, Your Honor, in Chesterton, Indiana, because I do care about my children, and I do want to make sure that my children are in a safe home and in good schools. I was baptized on December 16th of 2025 in Porter County Jail, the first person to get baptized since 2019, Porter County Jail. Not only was I baptized in Porter County Jail, Your Honor, it was a process. I was talking to Chaplain Berkey about it since early September. They walked in on December 16th, finally, after so many tries and him trying to find permissions and finding the actual tub to get baptized in and so forth. On December 16th was when my son that passed away's birthday, December 16th, and it was a coincidence. I don't believe it was a coincidence. It was God talking to me when he walked in and he said, "You ready today?" I said, "Yeah, ready for what are we doing?" He's like, "You're getting baptized today." And it was on my son's birthday. Your Honor, I'm asking for another opportunity to be a good father and dad to my children, to help us.
Shit, Kelly Newell, are you still here? Are you okay? I'm sorry.
Others in the community that have children that have passed away. There's not many words for it, Your Honor. As I was going through this time, the priest, the father from my church, my friends, my family, my loved ones, nothing that they said helped. It hurt so much. Oh, things are going to be okay. I'm praying for you. I know how you feel. All these things were not easy for a parent to hear when they lose a child. I know God has given me another opportunity, and I'm asking you for that opportunity. Your Honor, you won't see me again in this courtroom. I can guarantee that 100%. So I ask for your mercy, Your Honor. That's all I have.
Okay, sir. Thank you for your allocution. Thank you for the arguments of counsel. The court has had the opportunity to.
Okay, now we have to figure out, is Judge Fish going to hear the guilt and the progress this man made and give him probation, or 3 years, like they 3 years and then probation? Or is he going to give him 6 years? I think he said plus 2.5 years plus 2 years concurrent, so 10.5 years. I know, Kelly, I'm sorry, but you were to Tanner 1,000,000,000 times better than Miguel is to his son.
The pre-sentence report, pre-sentence investigation in this case appreciates the victim impact statement, appreciates the testimony of the gentleman who shared their stories or shared their testimony with us this afternoon. When we sentence, we start with the advisory sentence and we move towards more time for aggravating circumstances or less time for mitigating circumstances. And here we do have a situation where the events of March 29th, 2024 were a particularly hellish night for the victim in this case. I recall the testimony at trial, very significant for her and for the children that were present that night. It's clear to the court that the 3 counts are charged as separate acts. The evidence at trial revealed that there were separate acts related to the strangulation. There was rather evidence of multiple events of strangulation that night. The additional battery charge in count 2, it appears, is supported by additional evidence of punching, pulling hair, the bruising that the court saw on the pictures and things that were admitted into evidence that day. And then count 3 for the intimidation with the bottle. So those are very clearly separate counts in this matter. Our IRAS report reveals that Mr. Luna is a person who has a high risk to reoffend. And I will adopt the aggravating factors that are provided to me by our probation department, the history of criminal or delinquent behavior. And I certainly can't fathom, from my perspective, how one can be arrested 26 times and only be convicted 4 times for a misdemeanor and 1 time for a felony in his lifetime. So that is baffling, given the circumstances that I find you in today, Mr. Luna. You certainly have violated the protective order issued or violated the orders of the court on numerous occasions. We'll find that as an additional aggravating factor. I still have pending before me several cases with multiple counts for each case. The instances where it is alleged that you violated the no contact order or protective order that was previously issued by the court. And then you have also could be found to have violated the conditions of pretrial release in this case, or conditions of bond. So we'll find those aggravators. I'll reject the others proposed by the state at this time. I didn't hear any mitigators, but I don't think any mitigating factors apply under this circumstance. I do appreciate your contrition, Mr. Luna.
What about all the God pods? Are you telling me none of that is mitigating? None of it? Judge, there's 5 people up here, I think.
I often have people who aren't contrite, and I appreciate that you are today. I also am happy that you've done some work. I'm happy that you've developed these relationships with folks out at the jail. And I share in the tragedy, loss of your son, and empathize with your loss there.
Oh, he says he shares with it. Oh, Judge. Oh, Judge needs a hug. Oh, I have to go to Indiana right now. I have to go. I'm sure my car will make it.
Has to be something difficult.
Incognito, hello.
Certainly something I never hoped to experience.
Wait, you just said you shared with it, and then you just said, I hope I never have to experience it. Which is it? Now you're not getting a hug. Forget you. Now.
None of that erases what happened on March 29th, 2024. Doesn't justify it, doesn't make any of it okay. And because of the suffering that occurred that night, the significant battery, your significant criminal history, and the other aggravating factors, I think an appropriate sentence on count 1 is 5 years in the Indiana Department of Corrections, executed. Count 2, 2 years in the Indiana Department of Corrections, executed. And count 3, 1 year in the Porter County Jail. Counts 2 and 3 will be concurrent, and count 1 will be consecutive with counts 2 and 3 for a total term of 7 years. The request of the the request of the prosecutor's office is that the no contact order be maintained throughout that sentence. I'll grant that order. I'll also make a finding of domestic battery. You'll be Brady disqualified if you weren't already before. Your attorney can explain that to you. You understand the sentence, sir?
Yes, Your Honor.
Okay.
Your Honor, would the court consider giving a recommendation that he receive drug treatment in some type of continuing drug treatment program? I know he completed a lot here, and I think based on his substance abuse, I would ask the court to consider giving some recommendations. And also, I would ask the court recommending RWI.
Yeah, I'll reject that RWI request at this time. The main reason.
Judge, that's rude. That was rude. They asked for treatment. They asked for drug treatment. Judge said, no, I don't think so.
Being that I've got a level 2 felony dealing charge pending in this court as well. So no, I'll reject that at this time. I will notify you, Mr. Luna, that you have the right to appeal the conviction and sentence imposed herein. In order to do so, you may either file a notice of appeal or motion to correct error within 30 days of today. If you elect to file a motion to correct error, you must file your notice of appeal within 30 days of an adverse ruling on that motion. Failure to comply with these requirements will result in the forfeiture of your right to appeal. You have the right to be represented by counsel at all stages of these proceedings, including any appeal which you may wish to pursue. If you're unable to afford an attorney, I'm obligated to appoint one to represent you at no cost. Firstly, I guess, is the important question of whether you plan to appeal.
Yes, Your Honor.
And then secondly, Mr. Cantrell, will you represent him in the appeal?
Your Honor, my client is indigent. He wouldn't even have enough money to afford the transcript of the trial. Respectfully, Your Honor, he's been in jail for about 2 years. I'd ask that he be appointed an appellate public defender, and I'd ask to withdraw it.
Mr. Luna, I had previously appointed pauper counsel for you in the other cases that are pending before this court. I think I granted withdrawal of, was it Mr. Fontanez?
Yes.
In this case recently, and I believe that everything now is being handled through the Porter County Public Defender Service. Can you raise your right hand to be sworn? Do you swear from under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, Your Honor.
Okay, thank you. Has your financial condition changed at all since you've been incarcerated?
No, Your Honor.
And do you believe yourself still to be indigent?
Yes, Your Honor.
Your attorney mentioned that you previously had a business. Anything related to that business still in your possession that you could sell or use to as collateral to get a loan, anything of that nature?
No, Your Honor.
Does anybody currently owe you money?
No, Your Honor.
Okay. I believe I found you indigent before. I'll find you indigent here. I'll appoint the Porter County Public Defender Service to represent you for purposes of the appeal. While I've got you under oath, is there any restitution, Mr. Prosecutor?
No, not that I'm aware of, Your Honor. Let me verify. No.
Okay. Because I would have gotten into that examination as well. Okay.
Are you in Northern Ireland?
Sir. Sure, rather. I do see there's a $4,500 cash bond. From the cash bond, the court will retain court costs, the jail booking and sheriff's death benefit fee. The remainder will be paid on the bond assignment. You can approach with that, sir. Just make sure our bond assignment's squared away. I don't think there are any. Is there a domestic violence mandatory fee?
Yes, there's I don't remember how much.
$200 or
Yes.
$50? Might be 50.
50, it's a $50.
There's a mandatory fee of $50 that I'll also take out of that for $4,500. That's a required fee as well. Let's show that Mr. Luna posted his bond personally. You remember what day you filed your bond assignment?
I haven't filed it yet, Your Honor.
Oh, you haven't?
I'll file that.
Okay, yeah, Mr. Luna posted his own bond, so no counter signatures necessary. I do have the no contact order here, sir. I'll indicate that you're ready disqualified. That's related both to the convictions and the fact that there's a domestic violence determination that I'll enter as a result of this conviction.
I went through that exhibit too, Bren.
And you're not to have any contact, sir, with Jennifer Meyer. And you know who that person is, correct?
Yes, Your Honor.
Okay. Any contact with her can result in additional charges for invasion of privacy. You understand that?
Yes, Your Honor.
Okay. That typically carries a sentence of up to, it's a Class A misdemeanor, usually up to a year in jail and up to a $5,000 fine. I'm not sure if that would be enhanced for you or not at this point. Officer or Corporal Young, would you serve this, please?
That's true. So he was not found guilty in a trial. Not a bench trial, not a jury trial. He took a plea. So he can't appeal. The only reason he can appeal is if there was an error, like they said. If there was something procedurally or technically wrong with the plea. And that's it. And even then you have to get special permission.
And they'll get a nicer copy out to you, Joe. I will remand you to the custody of the Porter County Sheriff or transportation to the Indiana Department of Corrections. But before you're transported there, we'll deal with the remaining cases in this court. I think I have a hearing set and everything. Is that correct? Everything's set on April 6th at 9. We'll see you back here April 6th at 9 on the other charges. Do you have any questions about anything, Mr. Luna?
The question I would have is it possible to be sent to the Indiana Department of Corrections while the other cases that are pending get dealt with?
No, the burden on the Sheriff's Department would be too great. That is not administratively sound suggestion, so that would be denied. And I will grant counsel's request to withdraw from the case. We'll show your appointment terminated, not your appointment, but your representation terminated. Did you have anything you needed to add, though, before we adjourn
I can't think of anything, sir.
for the state?
No, Your Honor.
Okay, we are adjourned. Good luck to you, sir.
Yes, sir.
See, the per se one was better, wasn't it? That's why I scrambled and changed it up. Well, guys, so he gets 8 years, 7 years, 7 years, 7 years. And served, executed. So none of it is suspended. I don't know if he gets day for day because of his type of crime. So actually, I don't know how much time he's going to spend in there. Listen, I'm Irish. I am Irish. I married someone who's Puerto Rican. That's why my last name is Puerto Rican, but I am Irish. Kathleen Rose is my name. My sister was born on St. Patrick's Day, Patricia Ann. Kelly. Kelly was my maiden name. But I think Donnelly, I think, is where my family is, but I don't know. I just don't. Even though I went to Ireland, I didn't find out. I was too busy drinking. I drank a lot. I really did drink a lot, but I didn't really get drunk. I consumed a large amount of beer while I was there. And I did not get drunk. I guess I was just so excited to be there. Just, I don't know, metabolized better. Oh, but it's so beautiful there. You got lucky. I hope you got lucky. I mean, usually adoption that's a good thing. That's like, yay. But, guys, we made it. We made it to the end. I have zero stuff ready for tomorrow. We're in 6 hours. Nothing. Not 1 minute of court content ready. So, I have to go now. I have work to do. I'll see some of you in a couple hours. Thanks for coming out. Oh, Wednesday. I work next Wednesday night. So, no stream on Wednesday night. None. I can't stream from work. I'll probably get fired. So, only one stream on Wednesday in the morning. I hope you guys have a great night. I'll see you in a little bit. Thank you so much. Bye, guys. Love you too. I love you too.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her style is classy. She's always top shelf. Don't take my word. Come and see for yourself. Her cases are new with a twist or two. I really like them. I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf. Join in the laughter. Come and see for